Arguing motions at court in a debt law case. Brought to you by YourLegalLegUp.com, your advantage if you're being sued by debt collectors. It is possible that you could argue several different motions at court. You probably won't, but primarily these will be motions to dismiss, motions to compel, and motions for summary judgment, but there could be others as well. They may have different purposes and different issues of law, but they'll all follow as the same general pattern. Start with filing a motion. Let's say you file a motion to dismiss. The other side gets to respond, and you get to reply to their response. Without permission, there should not be any further response to that. So it always goes motion, reply, respond. But if you find something that's important, you should ask for permission to tell the court. That is, if they put something new in one of their motions, or you find a case or something like that, then you should ask for permission to tell the court. On a motion to dismiss, while it's sitting there, you do not normally have to answer the petition and the case just sits. So you don't usually have to call a motion to dismiss. The other side probably will. If they don't, the court will probably eventually dismiss the case for failure to prosecute. On the other motions, you'll also go through the same filing, response, and reply, but the person bringing the motion will probably need to call up the motion. That's unlike the motion to dismiss. That means specifically that the person who's calling the motion will ask the court to hear and decide the motion. Remember that you give the other side notice of everything you do, and this includes the calling up for hearing. You go into the clerk's office and choose a date you'd like to argue the motion. In some jurisdictions, they may just tell you what to do, what date that is, or they may set the motion for hearing automatically, although I think that's rare. After choosing the date, you write a memo to the court calling up your motion for hearing on that date and time, and you give a copy of that notice to the other side. Check your local rules to see how much advance notice you have to give them. It usually isn't much. If they've been cooperative with you, this might be a good time for you to cooperate back about dates. And if they haven't, well, you can select a date. But remember that you have to give them the proper amount of notice before the hearing. So if the hearing is if you have to give them 5 business days plus the mailbox rule, then you can't set your hearing for sooner than 8 business days, right? So you set the motion for hearing and you tell the other side. Now you prepare to argue the motion. The trick to arguing motions is to prepare as much as you can. The debt collectors know that, and they're also lazy, so you can expect their memorandum opposing your motion to be pretty basic, but they'll have more to say at the hearing. Don't worry about that. Prepare the argument from what you know and make a point of knowing everything you can know about the case. In other words, prepare to meet the best possible arguments that could be made against you, because they may well be made by the debt collector, or the judge might think of them. You have to be ready. When you're in court, if it is your motion, whatever motion it is, you need to take charge. Tell the judge what the motion is, and don't let the attorney take control of the situation, because the judge may well look to him or her first. Above all, you must not let the attorney for the other side state the basis of your motion. They may try, and if they do, you should actually interrupt them. It's about the only time you do interrupt, and say, "Excuse me, Your Honor, I'd like to tell you about my motion." Notice that you direct your comments not to the other side, but to the judge. Judges will let the attorney do all the talking if you let them, so don't expect them to step in and referee to make sure you get your say. But if you start talking, they'll make sure you get to speak your piece. And then, every time the lawyer says something that wasn't in their brief, which they very well may, you just make a point of mentioning the fact to the judge. If it's important and they didn't mention it in their brief, you can ask for time to respond in writing. But then you have to do that. You can't blow it off if you get special permission to write the judge a memo. Every time, if it's true, you say something like, "Your Honor, I feel sandbagged here. I sent them a letter to try to work this out, and they didn't mention anything like this in their response." Or you say, Judge, this wasn't in their brief. May I have a few days to research this and get back to you? Again, this part is only for something important, because then you really do have to write the memo to the judge. But you never want to get mad or emotional if you can help it. You're not going to win everything. You may not win much, and let's just say it's even possible that you won't win anything on your motion. Don't get psyched out. You'll still be fine. You're winning by gaining experience in the case and the law. You're gaining by requiring the debt collection lawyer to work on the case. And you're even winning by requiring the judge to work on the case. Most of them don't really like these cases, and they aren't above leaning on the debt collection lawyer to get them to let you go if it looks like it's not financially worth it. And they have high standards for that. You can't know these things while you're arguing, though, so just keep your cool and fight for every single thing. Now that you're there, don't give up on anything until the judge makes a ruling. And then move on to the next one. One of the great challenges in argument is to keep from letting either disappointment or excitement, as the case may be, from affecting you. As much as possible, though, make sure each question is a separate question, not affected by what went before. Fight for everything just as much. You can be reasonable and make compromises, but remember that each thing stands on its own. You don't agree not to get information about the sales arrangement because they're giving you something about the procedures to keep from billing someone who doesn't know. You don't know what they have. You have to have stuff on every aspect of the case. You can't trade one for the other. Also, remember to take notes. In many jurisdictions, the parties create the order for the judge to sign, and you want to remember and know what was said. A couple of basics. The person bringing the motion usually goes first. Like I said, don't let the debt collector speak for you, because they'll often try that. Speak for yourself. Make notes to go in with you. Notes about what you're going to say, because it's easy to forget. Lawyers and judges talk normally. They use plain English when they're talking, when they're arguing about discovery or other motions. Don't dress up your language. Just talk the way you normally do. Speak clearly, and if there's a microphone, speak into it. Don't yell, get abusive, or lose your cool. Stay cool. You're winning just by being there, and judges and the other lawyers will respect you much more if you keep your cool. Don't admit anything in court. Well, just remember that judges remember what you said, so if you say, I owe the money, or anything like that, the court could take that as a case-ending admission. Make sure everything you say to the judge is basically what you're saying everywhere else. Judges have a tendency to try to look at you and get you to give up. Don't. They don't know anything about your case, and if they know anything about the debt collection business, they know these cases are often suing people who don't owe the money, or for more money than they do owe. Don't give away the shop. On a motion to dismiss, if the other side makes an argument in court that was not in its brief, you can ask for time to research and respond. Or you can try objecting that they waived it by not making it in their brief. Remember, lawyers are trained to be persuasive. I've heard some pretty persuasive arguments for the other side just before the judge ruled in my favor. So make your best argument and believe in it. Debt collectors will say just about anything sometimes, so don't believe them, just fight. Motions for summary judgment are basically just like motions to dismiss at the argument stage, but here you may argue a little bit more about the facts of the case. I'll have a special video about motions for summary judgment. And you may need to make objections, so before a motion for summary judgment, be sure to read up on your objections and watch the video on that, making objections. Sometimes it's easy to think too much about the law, but legal cases are always about facts. Keep your focus on showing in a motion for summary judgment that they haven't proven the facts that they need to show in order to prove you owe them the money. In a motion to dismiss, that the allegations don't allege the facts that they need to show. Good luck. If you follow this video in your own common sense, you'll have an excellent chance of winning any motion. Do your best and have faith. If you liked this video or found it helpful, please give it a thumbs up, like, comment, and or refer it to a friend. That helps other people find it too. To get more help on fighting debt collectors and their lawsuits, go to Your Legal Leg Up. Get the litigation manual and forms. Defend yourself from the debt collectors.